This is Colin O'Keefe for LXBN TV. The much talked about NLRB posting rule is once again on the ropes after a ruling coming out of Washington, D.C. To discuss the most recent developments, we bring in Seth Borden of McKenna, and Aldridge and Labor Relations Today. Seth, first off, what can you tell me about this posting rule, just as background, and why is it such a huge deal? I've seen such a number of posts on our network over the past few months, but what's the background here?
Sure. 2011 was a fairly active year for the National Labor Relations Board, particularly in connection with its exercise of its rulemaking authority. And in August of 2011, the board promulgated a rule which would basically require all employers subject to the National Labor Relations Act to post conspicuously in the workplace a notice advising employees of their rights under the National Labor Relations Act. Those rights include the right to form a union, to join a union, to organize into a union, to be represented by a union, to engage in collective bargaining with one's employer, to strike, to picket, to engage in other concerted activities. Mm-hmm. And to refrain from those activities as well. Now, these are all rights that are provided by the National Labor Relations Act. There's been no change in the Act itself. This rule would simply have required employers to post a notice apprising employees of those rights and providing information about where employees could file charges at the National Labor Relations Board if they felt that their rights had been violated. Those rights. There were other elements of the rule as well, including a portion that indicated that the board would consider failure to hang this notice to be an unfair labor practice in and of itself, and a violation could generate exposure and liability for an employer.
I see.
And in addition, there was a provision that the board would consider failure to hang this notice as grounds to toll the statute of limitations, in effect, the 6-month period within which employees can file charges under the Act. Mm-hmm. Now, why the second part of your question is why was this such a huge deal? And I would submit that the latter elements of that rule, as I just explain them, were the huger deal. Yeah. The notion that failing to hang a poster would somehow in and of itself constitute an unfair labor practice was viewed by many in the management legal community as a sea change. The board has traditionally been a reactive agency, and there's nothing in the statute that requires an employer who has not otherwise violated the law to hang a poster like this. Mm-hmm. The remedy for an unfair labor practice has traditionally been the hanging of a notice to employees to apprise them of their rights. Yep. But the notion that any and all employers subject to the Act might have to do this was something very new, as was the notion that the failure to do so might create an open-ended period within which employees could file charges on other issues. The actual hanging of the notice itself is something that there was more mixed opinion within the management community about. This was not something that, while it was new for the National Labor Relations Board and the Act, this is something that most employers are accustomed to in connection with other areas of employment law, equal employment opportunity, workers' compensation. Anyone that's been in an employee break room probably is familiar with that wall of postings. Mm-hmm. There are some who thought enough is enough on the postings, and during a congressional hearing, one of the members of Congress referred to those postings as beginning to look a little bit like a NASCAR, the hood of a NASCAR vehicle. All these posters all over, maybe defeating the purpose of trying to pinpoint things for employee consumption. But I think the bigger issues were the issues that went beyond the poster itself and that went towards the board's enforcement.
I see. And what can you tell me about this latest decision coming out of DC? Because it was my understanding that we are on the cusp of having this rule go into effect. I believe just coming up very shortly, and now once again it's on hold. So what happened here? Why are we seeing this again?
That's right. Right after the board issued this final rule back last summer, several employer groups stepped forward and filed lawsuits challenging the implementation of the rule. And around that time, the board initially made the decision to postpone implementation. It was originally should have gone into effect, I think it was in November. Then they postponed it and indicated that they would not enforce the rule or implement the rule until April 30th of 2012. Now in March, around March 2nd, I believe it was, the district court for the District of Columbia issued the first ruling in one of these cases. And in a suit brought by the National Association of Manufacturers and others, the district court in that case ruled that while the board exceeded its authority with respect to the portions of the rule that would create a new unfair labor practice, which was not included in the statute, and with respect to the portion of the rule that would toll the statute of limitations, which again is provided for expressly in the statute, that the board exceeded its authority there, but it did not exceed its authority with respect to the underlying requirement of the rule that an employer hang this poster. That decision also went further and indicated that the board was within its authority to consider willful failure to hang the notice as evidence of an unlawful motive, evidence of anti-union or anti-act animus in other unfair labor practice proceedings. So this ruling came down, and I think many viewed it as a split decision. Fast forward a few weeks, and just late last week, a separate district court for the District of South Carolina, in a lawsuit brought by the United States Chamber of Commerce, ruled that the board lacked the authority altogether to issue this rule, and that none of the rule passed muster. And that obviously created somewhat of a split between the district courts on the issue. Mm-hmm. Following that order and following the creation of that split, the appellants who had appealed the D.C. decision moved for an emergency injunction. And the D.C. Circuit Court of Appeals issued that injunction yesterday morning, saying that in light of the competing, the conflicting decisions, and in light of the fact, in part, that the board had previously agreed to put off the implementation of the rule pending resolution of the litigation, the district court, the Court of Appeals, rather, enjoined the implementation of the rule. Following that, late yesterday, the National Labor Relations Board itself issued an announcement that it would agree to once again postpone the implementation of the rule to allow the courts to further consider how they're going to approach this and whether or not some resolution will be had that allows employers and employees and all of these various stakeholders alike the certainty that they need. Mm-hmm. So.
Yeah, I mean, as somebody who doesn't have, a vested interest in this, isn't, an employer or even an employment law attorney, I just see this as, I've seen so many updates. It's been, here's this poster, are we going to have it, are we not going to have it? Are we ever going to see some resolution on this? And, how do you think this is going to play out?
Well, the board is obviously hoping for some resolution one way or the other. They've indicated a willingness to postpone this indefinitely and to let the litigation play out. Right now, the D.C. Court of Appeals, in issuing the injunction, included a detailed briefing and consideration schedule with that injunction. And the briefs are now due in that case in May and June of 2012. And there was an indication that the court would be scheduling oral argument sometime in September of 2012. Now, if you play that out and there's oral argument in mid to late September of 2012, unless a decision comes within 4 weeks after that, you are smack dab in the middle of election season.
Yeah.
And I would submit that whatever this court is going to do or is not going to do with these appeals, I think the election on November 6th is going to have a great deal more impact on whether this rule is implemented or not than the schedule set by the court at this point. If we wind up having a similar National Labor Relations Board to the board that's currently sitting, which is, as you know, the source of some controversy in and of itself, then this litigation process will have to see its way through, perhaps even to the Supreme Court if we get differing Court of Appeals decisions. If there is a new National Labor Relations Board after the presidential election, it's entirely possible that that board would reverse or rescind this rule altogether. So I think that to answer your question, will we ever see a resolution? A lot's going to happen over the next 6 to 8 months, I suppose, that will go into that. But there's a lot going on right now at the board. This is certainly one piece of it. There's another rule that the board announced last year that is set to go in effect on April 30th, which will overhaul election procedures and facilitate representation elections and speed that process up in union representation elections. There is litigation surrounding that rule. There are competing summary judgment motions filed by the board and employer groups against that. There is a pending congressional resolution of disapproval to block implementation of that rule. And there is also litigation, as you and I actually have discussed before, Colin, over the issue of whether or not there's actually a quorum of board members appropriately seated right now. Because the president had exercised the recess appointment power at a time where many claimed there was no congressional recess. And just this week, Senate Republicans announced that they would be joining a lawsuit brought by a private employer in Washington State against the National Labor Relations Board and against the administration on this very issue. So there's a lot going on at the board right now, and obviously the issue of the board's overall authority will impact all of this. And as we discussed earlier, election year politics is certainly not likely to facilitate resolution of many of these things anytime soon.
Yeah, it's going to be interesting to watch. I mean, 2011 was a very, not tumultuous, but a very newsy year for the NLRB, and it looks like it continues to be in 2012. It's going to be interesting to watch going forward. It doesn't look like there's anything, doesn't look like there's resolution in the near future, but it looks like this may go on for a while and continue to do so. But once again, that was Seth Borden of McKenna, Long, and Aldridge and Labor Relations Today. Be sure to check out their publication. It's at, of course, laborrelationstoday.com. And we have so many posts on the NLRB posting rule at lxbn.lexblog.com, so be sure to check that out as well. Thanks, Seth.
Thanks, Colin.